Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have an update to the docket with the judge's ruling on Blake Lively's motion to strike in the Lively versus Justin Baldoni case. Yesterday, Bryan Freedman wrote a letter to the judge, and in that letter, he made the allegations that Blake Lively had attempted to blackmail Taylor Swift and to get her to delete text messages between them. Blake Lively later came back with a motion to strike that letter signed by Ezra Hudson, not Mike Gottlieb, who is alleged to have participated in this attempted extortion. Now, this motion to strike pertains to that first letter that was filed yesterday. Mind you, we just went over a letter that Freedman submitted today in which he signed that sworn affidavit outlining what his source, who is someone close to Taylor Swift, told him about what Blake Lively had said and done to Taylor Swift, including but not limited to threatening to release 10 years of text messages between the two. So I don't know what this ruling means for the letter that came out today with the affidavit, but here's what the judge had to say regarding that initial letter with the Taylor Swift information. Blake Lively moves to strike a letter, docket number 217. The motion is made pursuant to the court's inherent power to prevent abusive or improper use of its docket. The motion is granted. Courts have inherent power to manage their own affairs so as to achieve the orderly and expeditious disposition of cases. This includes the power to strike materials outside the pleadings that are abusive or otherwise improper. The Second Circuit has emphasized that courts should protect the judicial process from being co-opted to promote scandal arising out of unproven, potentially libelous statements. It has stated that a district court has not only the power, but also the responsibility to exercise supervisory power over its own records and files to ensure they are not used to gratify private spite or serve as reservoirs of libelous statements for press consumption. The footnote here says Rule 12F of the Federal Rules of Civil Procedure allows a court to strike matter within pleadings that is redundant, immaterial, impertinent, or scandalous. The letter is improper and must be stricken. It is irrelevant to any issue before this court and does not request any action from this court. And remember, that actual motion to quash that's in question was filed in the D.C. court by Venable. It concerns a subpoena proceeding in the District of Columbia, over which this court has no authority. The sole purpose of this letter is to promote public scandal by advancing inflammatory accusations on information and belief against Lively and her counsel. It transparently invites a press uproar by suggesting that Lively and her counsel attempted to extort a well-known celebrity. Retaining the letter on the docket would be of no use to the court and would allow the court's docket to serve as a reservoir of libelous statements for press consumption. The same is true for the Wayfarer party's subsequent submission at docket number 219, which the court will strike sua sponte for the same reasons. Okay, so that does include, that filing with the affidavit. I mean, you can't exactly dial back the information that the press now has, but they can strike it from the docket. The Second Circuit has noted that court filings may be abused to make potentially defamatory statements without the threat of liability, given that under New York law, absolute immunity from liability for defamation exists for oral or written statements made in connection with a proceeding before a court. It has advised the press accordingly that although the act of filing a document with a court might be thought to lend that document additional credibility, in fact, allegations appearing in such documents might be less credible than those published elsewhere. The motion to strike is granted. Counsel is advised that future misuse of the court's docket may be met with sanctions. All right, guys, that's all I got for now. Let me know what you think in the comments below, and I will see you all soon.